ORS, but they are established to oversee a unified system of early learning services and the Oregon Early Learning System created in statute. Goes on to define the division of the Department of Education. The division is such that we administer programs and funding, collects and analyzes data, and monitors program and contractor performance and accountability for the statewide early learning system. And we define a system, means the voluntary statewide early learning system established and described in 417728. Defines the hub, a hub, meaning an entity designated under 417827 and contracted by the division to coordinate early learning services in a specific region within the state. Relief Nursery is defined as a community-based organization that meets the certification requirements of ORS 414-600-0025, and that is, I'm going to say that's draft at this point. There may be other rules that we'll have to reference here. I've defined therapeutic early childhood education program. And the reason I defined it in this way, you'll note that this is different than most of the relief nurseries are accustomed to. Other definitions include the term therapeutic early childhood classrooms, and in that definition it included home visiting as a component of the classroom. I decided to go ahead and take the home visiting out and define it elsewhere in rule so that we don't have any confusion or potential interpretation that that definition meant that home visiting had to comply with the staff ratios that are applicable to classrooms.
Oh, so you took out home visiting so that later when we talk about ratios, it's clear that we're only talking about classrooms? Is that the rationale?
Yes, and another way of putting it is that it is clear that the ratios for the classrooms do not apply to home visits. You do not need to have 3 staff members going out to a home visit of a family with an infant and a young child.
Okay. This is Kelly, and I have remarks with regard to this section whenever you guys are ready to hear it.
Okay, I just, let's get it all out, Kelly, and then start a conversation. I think one of the things that there was some discussion that we would like to add a definition for the Oregon Association of Relief Nurseries because they're going to be referenced in the rule. Lisa, is that correct?
Yeah, that is one suggestion I received over email, and so it is in my notes, but it's not in this version. That
yeah. So, Orrin, you can help us in the definition, but we've already noticed the need for a definition of Orrin because Orrin gets referenced. Lisa, do you have anything else on your list that you're planning to add to the definition section?
Not at this time, no.
Okay, so now let's open for discussion. And Kelly, you said you have some comments.
Yes, the actual name of the program is the Therapeutic Early Childhood Program. The word education does not exist in the name of the program. This is the name of the program. It's copyrighted material, and there really isn't any way for it to be represented other than Therapeutic Early Childhood Program. In parentheses, we just use the acronym TECP. So that should read Therapeutic Early Childhood Program, means programs that include therapeutic early childhood classrooms that provide developmentally appropriate activities and interactions. The line as determined by the division is not appropriate. It's not, I don't understand what it means. That should be deleted. And with regard to removing the home visiting from the reference here, home visiting is part of the program. So I think it's implied that the ratio in a home visit there wouldn't be the expectation that 3 adults go on a home visit. So if there needs to be some clarification of that, it should come at a later point or here parenthetically or however. But home visiting is a core element of the therapeutic early childhood program, which includes classroom activities with therapeutic adult to child ratios and home visiting by the teacher. That is the program. So those are the changes.
Lisa, did you consider adding a definition for home visiting when you took it out of the therapeutic early childhood?
Well, when we get down to the core services section, it is described down there, and we will see whether or not it's sufficient. But it is described later in the rule.
Okay, but I have to stay firm on this here because it simply is referring to a program that doesn't exist. The Therapeutic Early Childhood Program is the name of the program that is operated by all Relief Nurseries, and it's certified by RN.
Lisa, is there any reason to have the word education in that definition?
No, there's not. I can just...
Okay. So, is there anybody who thinks the word education should be left in, since this is a term that is used by the relief nurseries? Is there anybody who thinks we should add the word education to the term they've developed?
Can I have I have a clarifying question. So we have decided, so the question is because it has many implications. Have we already decided that it's Oren that's making the certification? It's actually certifying relief nurses?
Well, that's coming up in the rule. And so when I said I thought the group I thought had come to consensus on that, but we're coming to that. Hold on to that, Elvis. We're coming to the rule language. It's still coming.
I'm just saying that because all that has implications. If we're picking language earlier about things that we haven't decided yet, I just think it has implications on the language in all of these things if we haven't already decided that.
Okay, so it sounds like we should put definitions on hold and see if when we get through the next work we can come back to it. But it sounds like we are not ready that people want to see what's coming before they weigh in on whether these definitions should go forward. Did I capture it? 5. Okay, great. Okay.
Kelly, I'm sorry. Bobby, it's Kelly. I just wanted to mention one other thing.
Okay.
Our position on this is not negotiable. This is not the name of our program. And this material is copyrighted. And it's represented in our quality assurance standards, and it's represented in our replication materials. That's the name of the program. It's not negotiable. It's not up for conversation. That's what we call the program. The other thing, too, is this is the way that this will be referenced and referred to in the legislation that has been dropped, in the legislation that's pending right now. It's just the name of the program.
Thank you. Okay. Lisa, are you ready to take us onto the certification section? We're putting this section on hold.
We're putting the definition section on hold. Yes, it's like I said earlier. That definitions are always a work in progress. So the section 0020 certification of relief nurseries is next. This is the topic of conversation that Elvis was asking about, and we have designed the rules to reflect a policy of the division that the Oregon Association of Relief Nurseries shall be the certifying agency and solely responsible for certifying relief nurseries under their model. We need to make a linkage between the certification requirements the certification process and any other activity relating to certification, like revocation of certification or appeals to the funds and the contract that the state issues. This section is intended to describe the conditions under which and by which the state will fund and contract with an entity that is certified as a relief nursery.
So, somebody please go on to mute because we're hearing background noise. Okay, so can you, Lisa, I'm not sure that I completely understood what you just said. That this section is going to document that or put in rule that ORN certifies and that that in order for somebody to be called a relief nursery, they have to be certified, or for the purpose of the funding, they have to be certified as a relief nursery by ORN. Is that correct?
That is a correct statement, and we will get into the eligibility for state funds in a little bit in the rules. What this section says is that ORN shall certify relief nurseries according to a process that we have to outline in rule, and that's why we have this little placeholder here, and that there is an application process for that, and that's the second section, or second paragraph. Certification is contingent upon a relief nursery's compliance with these rules, and that we will have a communication link to ORN, the division, letting them know if a relief nursery fails to comply with the rules or the contract. So what I said earlier was that the intent of this language is to describe the conditions under which the state will fund and contract with an entity that has been certified as a relief nursery.
Okay.
I will pause to see if I need to clarify any more.
Can you go through the very last paragraph? Upon receiving notification. What is that? Tell us the purpose of that.
That is to ensure that we have relief nurseries relief nurseries in compliance with the rules and the contract, and it provides ORN an opportunity to review the relief nursery certification and take corrective action to bring the relief nursery into compliance with the rules or the contract.
Okay. This is Stephen Mandel. I'm gonna step in just because I think this is just sort of a little bit of useful context, and I know this isn't always the case, but the Early Learning Division has taken a position that we do support the formal recognition of the role of ORN in certifying relief nurseries, and recognize that funding for relief nurseries needs to be tied to that certification process. We as a state agency, though, also since we are administering these funds, have a set of responsibilities around the administration of funds, that we also will have a position as an agency at various points on, for lack of better words, some checks and balances in that process. So, since I think we actually do have a bit of an agency position on this one, I just wanted to put that on the table from the beginning.
That's very helpful, and I think it addresses Elvis's question. So let me ask Elvis, did that answer your question?
No, because I'm a little concerned just because there's a lot of things going on in the legislature where there's the need for checks and balances. And the way that I read this is that ORN is the only one who can certify or bring into compliance relief nurseries. And so if we look at the first line, this is Oregon Association of Relief Nurseries shall, if that's a may, and leave some of it within the state too to bring into compliance, I would feel more comfortable.
Okay, I think these are two separate things. I think the first is certification. The second is what happens, who monitors compliance. And so, Lisa, can you tell us what this language says? Because it says the division shall notify ORN if a relief nursery fails to comply with the rules or the terms of the contract. So the question is, what does that mean the division's role is in relationship to the question that Elvis raised?
Well, in relationship, excuse me, to what Elvis was asking about, ultimately the agency is responsible for performance of the contractor. In this case, that's the relief nursery. The contractor must comply and conform to the terms of the contract. In this case, the relief nursery or any entity that seeks state funds to provide relief nursery services must be in compliance with these rules. We have a rather unique situation in which the provider of these relief nursery services are certified by an external entity, and that there are issues with, as Mary Ellen mentioned, trademarked models. And so we, as a division, as Mr. Mandel indicated, have, we believe that that is an appropriate role of ORN to certify relief nursery. What I'm trying to do is make a linkage to connect the role of the agency in monitoring compliance with rules and compliance with the contract, and ORN's responsibility to maintain and monitor compliance with the certification requirements.
Could I ask,
Elvis?
Go ahead.
Elvis, do you still have a comment or a question before we move on to?
I'll move forward. I still have concerns just because I've never really had. I'm not really well, an external organization having certification for state provided funds. Like, I know that there's a need, and I know that having the state do it would also be additional funds. So I just have concerns. It's not anything that I'm against. I just want to have a little bit more clarification of like where we fall on all these things.
Okay.
This is Kelly. I'd like to offer a thought on this.
Well, just a second, Kelly. Tim had already tried. I held Tim back so that Elvis could finish. So you can be in the queue right behind Tim.
Thank you.
Mm-hmm. Tim?
Yes, my question is really around how this is similar or dissimilar to Healthy Families. But it seems like the Healthy Families program is there's a national accreditation program through Healthy Families. And is this the kind of relationship that ELD has with Healthy Family programs? That's my question.
So, Lisa, you're the person to answer for the rules. Nikisha, I don't know, which of you wants to answer Tim's question?
This is Nikisha. Tim, can you repeat that question, please?
Sure. So I know Healthy Families requires certification through Healthy Families of America. So it's an outside certification process. I'm not incredibly familiar with it. But programs in Oregon need to qualify in some way in order to receive state funds. I was just curious if this relationship parallels a relationship with Healthy Families of America.
Okay, so let me just sort of describe that process for you all a little bit. This is Nikisha. So the state determines who to fund and many of you are aware of the RFP process that we underwent a couple years ago, a year and a half ago or so. So through that process, we determine the site, and then the state supports those programs to become Healthy Families America program. So we support the programs to get certified under the model.
Nikisha, if somebody didn't make Healthy Families America certification standards, what would happen?
If they didn't meet the standards or the requirements of the model, then the state would not be able to fulfill our fiduciary responsibility. We would not be able to fund that entity.
This is David, and I think I'd like to clarify, because I think there's two important understandings of accountability on the table, and I think they're both really important. And I think if we think about the different kinds of accountability, it might help think about the different roles we're proposing for ORN versus the Early Learning Division. So one is accountability around fidelity to the model, and I think there are models like with Healthy Families of America of having a non or governmental entity assure that kind of fidelity to the model. Then there is also an accountability role that we have as a public agency to make sure that terms of contracts are met, that funds are used appropriately, that the entity has completed its certification process, not necessarily to do the certification, but to verify that that's happened. And so I think what we're trying to do in this draft rule is have both those forms of accountability present with the different roles, but that also means necessarily some connection points that we'll try to articulate. I don't know if that was helpful. Or
can somebody go on mute? Yeah, it's really hard to hear. Okay, thank you. So,
can I pose a quick question? Oh.
Okay. So, well, okay, but Kelly, Elvis, can it hold? Because Kelly's waiting. Okay, I've got you though. Kelly?
Yes, Bobby. I think that, the one piece that's missing, and it's just a very clear concept, which is that relief nurseries are not state programs. We're not a state program. We're not analogous to a state program. We're a contractor to provide services. But relief nurseries exist outside of the realm of state funding. So that's the piece that maybe Elvis is missing in terms of questioning this. So relief nurseries are independent organizations, and we're not a fully funded state program.
Thank you. Okay. Elvis?
Yeah, no, just to answer that, I do understand that, but we regulate everything, even if it is in part state funded, right? We regulate insurance, we regulate a lot of different things. But that's beyond the point, I guess. So let me ask a question. If someone were not certified by ORN but did meet the standards, would they still be able to access funding?
Not as this rule is proposed, Lisa, right? This is saying that they have to be certified to be eligible. Is that correct?
That's correct.
I'm done. Thank you.
Okay. Tim, in answer to your question, I asked that question months ago, and it seemed, other people can correct me, it seems to be the big difference between Healthy Families and relief nurseries. Well, one is the point Kelly just made, that I don't know if Healthy Families get external funding or if they're only state funded. But the big difference is a program can be eligible and will be supported to meet Healthy Family standards, whereas what these rules, as I understand them, are saying is you're not eligible to get a contract unless you have already been certified by ORN. So I'd like other people to weigh in. Am I correctly understanding the major difference between these two models? both of which require certification, one in order to be eligible, and the other is to meet compliance. Both have to be certified by an outside organization, but the difference is, one, this would say you're not eligible unless, and the other one says you can't, you're not in compliance and you can't continue to get funding if you don't meet these standards. Lisa, Nikisha, is that accurate?
From what I understand about the Healthy Families Oregon rules, and I'm sorry, this is Lisa, that is a fairly accurate statement, Bobby, and it's just a very fine line. It's what comes first, certification or funding? And in this case, as it's proposed, certification would have to come first.
Right.
So
okay, other members of the committee, oh, Tim?
Well, I guess I have a concern about this section kind of related to what Mary Ellen started with. And it seems like it's a tricky issue to solve, but if ORN and if it was a nationwide organization, I think the state would be less likely to put the certification rules in the Oregon rules. If we were Head Start or Healthy Families, or if it was a broader movement, I don't think the pull or push to put an appeals process to our certification would be in this rule set, because you'd have no influence on that state agency. So it feels like an overreach.
You mean on the certifying agency, like Head Start or Healthy Families?
Yeah. Yeah.
Okay.
I mean, a Head Start program that lost its certification as a Head Start program would lose its state funding, I assume. And they'd have to work it out with Head Start America or whatever it's called.
Uh-huh. The Office of Head Start is what they're called, yeah. Uh-huh.
So sorry. I don't need to use the wrong
So
language.
you think that the reason for putting, Tim, I just want to follow the logic. The reason for putting certification in order to be eligible in these rules is that ORN is it's an independent Oregon organization. Is that what you said?
Yeah, it's a small organization, and
okay.
That's the crux of it. Thanks, Bobby.
Okay.
This Danelda, to maybe
welcome, Danelda.
To grow on this, though it says not only do they do the certification, but ORN also does the compliance. So in order to be, I mean, it seems like it goes together. Who's certifying you, and then it looks like the state will monitor, but the compliance is also with ORN. So it completes the picture.
Yeah, but that makes you feel uneasy.
I find that unclear, Danelda. So, Lisa, this says, as I read it, had the division doing monitoring of compliance, and when they found that a program was out of compliance, they reported that to ORN. Is that what this rule says?
That is what this rule says, yes. And that is
do they get to keep their state funding even if the division finds them out of compliance with ORN rules?
Well, a number of things can happen. This is to give ORN an opportunity to take corrective action, or to, visit with that relief nursery and figure out what it's going to take to get them back into compliance. The other option, or another option that the agency has, frankly, is that we can reduce their funds You know, or, so what we're trying to do here is involve ORN in the fidelity, to maintain fidelity to their model and compliance with the rules.
I want to go back to the two kinds of accountability because I think that's really basic to this. So I think the idea is we both want to make sure that a relief nursery is remaining with fidelity to the model, and that's part of ORN's certification process and its ongoing making sure that the certification is current. And we as a division entrusted with public funds also have a responsibility to make sure that the terms of those contracts and those funds are being used appropriately. I see those as both sort of simultaneously parallel and connected. So I'll give you two different scenarios. One is we want to have the ability, if ORN revisits the certification of a program and finds that it's way out of whack on the model, pulls the certification, that should also trigger the Early Learning Division to revisit that contract and lead us to the question, do we also need to pull that contract? Simultaneously, we want to be in a position where if the Early Learning Division in monitoring the contract, and I'm just using this as an example, discovers that there is a major misuse of funds, we also want to create a situation where ORN, when notified of that happening, can revisit its certification and pull that certification. Because ORN does not want to be certifying a relief nursery that's in gross contract violation, and the Early Learning Division does not want to be having a contract with a relief nursery that's failing to maintain the model. And so we're trying to have those two parallel pieces, but also build in those connection points.
This is Kelly. That sounds right to us. That, you know, that explanation and that parallel and yet connected process where we're protecting one another.
Any other comments on this section? Or actually, it's not, Lisa, have we been through the whole section or just part of it?
Well, I will just call your attention that the areas that you see highlighted here just indicate that I need to continue to work with ORN to describe in rule the application for certification process, as well as the conditions and process, conditions that would result in a revocation, and what does that process look like. We have to call those, we'd like to call those out in rule. So there's some missing language here at this point.
So it sounds, oh, Elvis?
I appreciate that. I guess that was the concern that I was having, is just that if we haven't had what the parameters were in rule, and then the other thing is that we are very narrow on the agency that's certifying. Have we ever, is there any procurement or has DAS been looped into some of this? Just to, because it seems like we're preferring one over another. So that's just, I'm fine with that. I just wanted to make sure if we had, there just seems to be some procurement, contracting stuff in there. So I just wanted to put that out there.
Bobby, I had one other remark whenever you're ready for me.
Okay, just a second. I'd like to clarify. My understanding is there is no contractual relationship between the Early Learning Division and ORN, just like there is not between the Early Learning Division and Healthy Families America or the Office of Head Start. Am I, Lisa, is that correct?
That's correct.
Okay. So Kelly, go first. It sounds to me like, Lisa, I just want to clarify. Lisa, it sounds like you're saying we need to put this one on hold because it's still in progress. Is that correct?
Yes, I have solicited some language suggestions and solicited some materials from the association so that I can You know, so I can understand
Okay.
what their processes look
Okay,
like.
so we're not going to
I can
vote.
describe.
We're not going to try and reach consensus on this section because it's still under development. And but
Well, Bobby, let me clarify, if I may, Bobby. This section, certification of relief nurseries. No, I don't need to add any more to that. What I do need to add, you'll see later. I've got some things reserved here for certification process, and we'll add the process in here and the revocation in here.
Okay, this section we can see if we're at consensus on, because the things that are unfinished are later in the rule. Is that accurate?
Correct. Yes.
Okay, Kelly, I know you. I'm sorry you had to wait. Can you share?
I think we can just move on if it's on hold anyway. I mean, my point really was more speaking to Elvis and the question about the parameters and the role. You know, the relief nursery OARN, we own the model, so there's just some of these things really just aren't up for discussion as far as we're concerned. I mean, they're part of the model, the fidelity of the model that both David and Lisa have referred to with regard to maintaining fidelity to that model and compliance. So we're fine.
So Kelly, I think I misspoke about putting it on hold because I thought Lisa was adding to this section. So we may take it to council, but if we're at consensus, I just misunderstood and thought Lisa was adding to this section. She says she's not. It's going to come up later in process and other sections of the rule. So let me find out, are we in consensus on the certification as written in this section, which is basically ORN has accountability for fidelity to the model, and the early learning division has the contract accountability performance function. So let me ask, is there, okay, Elvis is 3. Anybody give this section less than a 3?
So, Bobby, this is Christy. I'm sorry, I can't see anyone anymore, so I'm having a little trouble participating in the FIStify. But I have a couple questions. Then I guess I'm a 2. All right, I'll just give a 2.
Okay. How about, you know what? When anybody gives a 2, what we'd really like is to know what the issues are, because we'll take them to council.
Okay. So what you just said, and I think what David's been explaining, also makes a lot of sense to me, which is this kind of bifurcated accountability. One is around certification and compliance, and that would, all of that authority around that accountability would live with ORN. And then the meeting the terms of the contract, right, is what lives with the early learning division. But that's not clearly stated here, even though that's what I think, Bobby, you just were trying to summarize. Maybe I need to read really more carefully.
So your concern is not the concepts that have been described, but the language actually in the proposed rule you think does not communicate what we have been saying verbally.
Not very clearly. So thank you. That's a good summary. And then I guess kind of a sub-point there is this also this comment earlier around the bidirectionality, right? That the division shall notify ORN, and then this question of, is that also true that ORN will notify the division? So that bidirectional communication around certification and compliance, either for the fidelity to the model or the contract, I'd like to see or say I have a question about that. That sort of bidirectional language isn't also very strong. And then one final comment or question that's actually just a small logistical one is on paragraph 2. It says applicants for certification shall complete and submit all forms and provide. And does that mean shall complete and submit to early learning division all forms and provide?
You want clarity on provide to whom?
Yes.
Okay.
And in that same
Okay.
paragraph, it says these rules, and is that in reference to the ones that are in yellow? So
That is
just
in
more
reference
clarity.
to the, okay, that is in reference to the entire 414 Division 600, but we can list it all out.
This is Kelly. I would agree with Christie's remarks about the almost, I would agree that it's not clear. The language here doesn't appear to reflect this discussion and these points that were just made by Christie and earlier were made by David.
Okay, so what I'm hearing is that we are not in consensus because we want clarity in the language. We are in agreement on the basic concepts, but Chrissy, it feels like there's one thing that's maybe just not addressed or not resolved, and now I'm not sure I can name it. It's the bidirectionality. I got that. Clarity, providing to whom, more clarity. But is there another? Did you have another question that is simply just not addressed?
No, I think that's been captured.
Okay. All right. So what I'm going to recommend is we do put this on hold, actually, and ask for revised language, and in terms of giving the council update on what we're doing, we'll just describe briefly this conversation and what we want the rule to be doing.
Harvey, could I add one last statement? I didn't quite get it.
Oh, yeah, sure.
The other red flag for me is around the reference to a certification process called out in rule. So for me, that reference to the certification process, I don't think that should be there.
Can you read the sentence that you think should not be there?
It's the very first paragraph that will certify, ORN will certify relief nurseries, but leave out the reference to the administrative rules on what that process is. So the certification process would not exist in rules, it would exist in ORN.
Lisa, I think you told me that we didn't have a choice on this one. Is that correct?
So our understanding is in order to have the funding connected to ORN doing the certification process, the rules also need to have sufficient reference to what that certification process is in order to create a strong enough tie for that funding to be contingent on it.
Okay, so I know there's been conversation from the beginning where we had wanted to take out of rule anything that didn't need to be there, but my understanding, David and Lisa, is we've been advised it has to be there.
Yes, to clearly make, to be legally sound for these rules, we have to have it in there. That is the policy direction that we are taking in these rules.
Is it the word process? I mean, could you, this is Neld, I'm sorry. It says according to the process established, or could it just be that the ORA gives this permission to ORN?
This particular rule would describe the process. And so,
it is process.
Yes, it is the process. I mean, I don't, yes.
This is Kelly, and I would just go back to the statement that was made at the beginning by our executive director at OARN, that it's our position, OARN's position, that the details of the certification process should not be represented in rule. They live with OARN. So this is an area where we would...
That may be the position, but in order to have the funding tied to that certification process, there needs to be sufficient grounding in rules for us to be able to do that. So in order to get that certification process to be the basis for funding, we need a grounding in a rule.
All right,
So
I guess just
this is a substantive issue. Partially it feels like it's a legal issue for staff to work through. So let me ask this, David and Lisa, have you done all the work on it that you can do? And this is this DOJ's position? It's this way or not at all, or is there still room for more exploration?
This is the policy direction that the division is taking in order for us to have sound and legally sound administrative rules that are defensible.
Okay, this one goes to council. Okay, so let me just capture the issue. The ELD policy is that in order to have legally sound basis for acting, the ORN process needs to be in the rule. ORN has stated that they do not believe it belongs in the rule, and just that all that should be in the rule is that it's an ORN process and nothing more about what that process is. So if I just want to take the right issue to the council. Have I stated the issue accurately?
I think so. This is Tim.
Okay. All right. Well, good. We'll take it to him in a couple weeks and go from there. Okay. I think we're ready to move to the next section, and it's 2:20 almost. So we had hoped to make our way through all of this, but if we can't, we can't. I don't want to cut off conversation. Lisa, will you take us to the next section?
Sure. So we're going to skip this section because this is what we were just speaking about. So if you move to 0030, I just want to give you a very large caveat. This language that in here is not final. This is just to try to convey the intent. We need to continue to refine this particular language as well. So I just want you to all know that this is, again, just trying to convey the intent, and which is that if an entity who is seeking certification as a relief nursery through the Oregon Association of Relief Nurseries is unsatisfied or disagrees with the decision of ORN, that there is an appeal process or a review process, however you want to call it, and I've kind of tried to lay it out here. The first step would be that the entity who is, seeking a review or an appeal would submit a request for review by the ORN Board of Directors. Then the next step would be, and then it just really says that there's no real formal or specific format, just as long as it's clear, there's a rationale for the disagreement and what the disagreement is, what decision the disagreement is related to. Then the entity's appeal is considered timely if it's received by ORN within 60 calendar days. ORN shall notify the division that they've received a request for review by a particular relief nursery. The Board of Directors shall initiate that review, maintain an appeal file, records relating to the appeal, document their decisions, their deliberations, and then the Board of Directors shall notify the entity and the division of its decision within 60 days of receipt of the appeal. Now these days are, subject to review because we could be creating a very lengthy appeal process without even without considering the timelines here. The next step then for remedy, if a member, that shouldn't be member, if an entity is not satisfied with the outcome of their appeal, the entity may then request a review of Oran's decision for a final adjudication by the division. Again, it's just trying to keep things moving along timely. Again, let's review these timelines when we get to, when we figure out what the process looks like. And then ultimately the division has all final decision-making authority on certification appeals.
Okay, let's open for questions or comments, either one.
Okay, this is Kelly, and you know, again, the issue with regard to this is really the adjudication, the ultimate adjudication. We've contended all through our meetings, and we do not have consensus on this because the final decision with regard to certification lies with OARN. The state can't require us to certify a relief nursery if we don't feel that they're, if they meet the standards, the fidelity to the model and the standards set out through OARN. The state could certainly decide whether or not it wanted to allocate money to that entity and could do so through other means, or you know, I don't know how that would look, but the state has no role in the final decision making with regard to certification of an entity. That lies with OARN. We have no consensus on this.
Other comments?
So this is my concern when we say that ORN is the only body that can certify, which, yeah, I feel like, yeah, they can certify who their members are, and I'm totally in agreement because that's their realm, an external group. But for this purpose, where I see this is where I see the rub. If it gets to the adjudication point and the state says, yes, we're going to give you funds, but then you just made a rule that says that these are the only groups that will be able to do is if they're certified by OARN, then now you've come into conflict in two different rules. So this is my, like, that's why I was suggesting in that other rule.
Well, no, they're not eligible for funding unless they're certified. So I don't see the conflict.
Except if the final decision in adjudication says, yeah, they are a relief nursery, and then they come into conflict. Am I making sense?
I think I'm missing something.
So they go through the process of what have you, if they're certified or not. They get to the adjudication point, and it says the state could say, yes, we've adjudicated, we side with this provider.
Well, no, they have to be certified to be eligible. So the state in processing, they have to be certified.
And there comes that's what I'm getting at. That comes the rub. So if in the adjudication point the state says, hey, yeah, no, they seem pretty good, but now the previous rule.
No, the state is saying you have to be certified in order to be eligible. Then the process I think we're talking about here is some organization had applied to be certified, and they did not, they were not certified, and they want to appeal that decision. Is that, Lisa, is that correct? This is an organization that applied to ORN to be certified and were refused. And they come to the state, and there's an appeal process that is ELD working with ORN on resolving the question of whether this organization does qualify for certification. Is that what this is saying?
So this is David, sorry, so I just want to give you what you're because because there is public dollars associated with this, there needs to be some kind of external appeal process beyond ORN in order to sort of close the loop. So I think the idea is for this not to be the norm by any means, but there needs to be, if public dollars are associated, tied to the certification process, then there needs to be some kind of an accountability mechanism where someone has an ability to appeal the decision.
Okay, so can you keep talking? So Kelly says the state's responsibility deals with money, but this is money, because if somebody is turned down, then they cannot, they're not eligible for the state funds. So there is money, there is state money, and so what you're saying is the state, if the state is going to refuse somebody's eligibility, there has to be an appeal process dealing with that refusal. Is that?
That's correct. I think you stated it quite well, Bobby. We should not.
And then my question.
Okay, just a second. Is Elvis is in the queue? Is somebody else in the queue?
I guess I'm in the queue. This is Kelly.
Okay, so Elvis and then Kelly.
So my queue is my question is, so what happens if someone goes through the process and the person who comes on top is the state decides with that provider?
No, the process we're proposing is that there are state dollars, one thing. On the other side, there's certification with ORN. In order to be eligible for the state dollars, somebody has to have made it through certification by ORN that they are faithful to the ORN model, to the Relief Nursery Rule.
But we're in the section that says appeals, and so I'm concentrating on the appeals process. So this is
somebody applied, somebody knows their state dollars, that's why the state's involved. And
can I clarify just 1 second, because I think I'm just more focused on the part that says adjudication of appeals, and this is the thing that Kelly brought up. The division shall make final decision on all certification appeals. So what if the state sides with the person and not OARN? That's the crux of it. What happens then?
Okay, so the person applied to OARN and they got turned down for certification. And then because there were state dollars then that they were not eligible for, they kick into this appeal process as it's described. And the Early Learning Division then has a process for working with ORN on this organization's appeal to their decision to not certify. And then the question is, what happens if ORN says, you're right, we're not going to certify them, and the state says, that's not our final decision. Is that's your question, Elvis?
Yes.
Okay, Lisa and David. So ORN turns the appeal down, but the state says that was a valid appeal, and so then what?
Correct. What happens then?
They would be certified.
But the only entity that certifies them is the one that turned them down.
That's what I'm getting at.
Sorry.
Yeah, the
state can't certify. The state can't certify. ORN can only certify.
Right.
So then.
This is Tim. If I can just jump in, it seems like this is a subset of the certification process. So it seems like that's kind of the big issue. Because the way this is written is ultimately the state could decide that's a relief nursery, and OARN may think it's not. But the way this rule is written is the state has ultimate authority. And that's an issue for relief nurseries. So it seems like it's connected to that bigger certification process.
This is Pam.
So it's the ultimate authority. So Kelly, your point was the state should have say over who it funds, and Orange should have say but on whether someone's faithful to the model. The challenge is when we've linked the two by saying eligibility required certification, then we have to find some way to protect organizations so they have a fair chance to public funding. That's really the question, isn't it?
Right.
It's not, it's not that.
I would say a little bit just a fair chance of has to be some kind of external appeal process. It's a little bit of a different stake and fair chance for funding. I think an appeal process is a much more limited than saying something about the fair distribution of funds. But, you know, so what I would interpret this is an appeal could only be based on foreign certification standards, right? So someone couldn't come to the early learning division and say, we don't like the standards and we still want to be a relief nursery. But there has to be some kind of, since public funding is attached to it, there has to be some kind of external appeal process for someone to say, I did everything I was supposed to do and my certification was denied. So yes, it does give the early learning division a point of a final appeal, but it defines the appeal as still being based on those certification standards.
Right. This is Kelly.
And that was my issue with.
Okay. Kelly, I heard you.
Ending,
okay, Elvis, go ahead.
and that was my issue with the last rule that ended in 0020, where it says shall, and that it didn't say may, and that's why I brought it up earlier, because I foresaw some of these issues coming down the pipeline if they were the sole certifier.
Okay, Kelly.
Okay. Yeah. We are the certifier because our relief nurseries exist outside of the realm of the state, and so the state cannot compel OARN to certify anyone. Now, having said that, what David's point was is if the ELD adopts the OARN standards, and you could demonstrate that we abused or misused our power or we misinterpreted a standard, well, that's one thing. That's the appeal process I believe and hope the ELD is talking about. But other than that, there really is there's no precedent. OARN cannot be compelled by the state to certify any nursery because that's what we do. It's our model, it's our work, and we certify. And if you are to receive state funding, you have to be a certified nursery. If the state adopts our standards, then and can demonstrate that we have abused our power or we have misinterpreted or misused the standard, well, of course, sure. But the final decision does not rest with the ELD on this. And this has been a point where we have not reached consensus through all of our discussions.
Okay, so what I'm hearing is there is agreement that certification to call yourself a relief nursery is an ORN function, and that funding decisions are an ELD function. So because the two are linked, when an organization perceives that an error was made in the certification process, then they need to have an appeal. And ELD, this process then connects the two, because the person is being deprived of funding because they were turned down. And so the appeal would be about the organization saying we met all these standards and we were not certified, and it's done with ELD and ORN, with basically ORN reviewing their own work. But we still get to the end when, I mean, I can't imagine this ever happening, but anyway, we get to the end and ORN said, we stand by our decision. It looks to you like they met all those standards, but it doesn't look like that to us. Then what happens? I think that's what everybody's trying to understand.
They can give them money.
And the way this is written, it says the division makes that final decision, and that's where the conflict is. I think.
Well, or Donalda, lack of clarity. That the division thinks, okay, you get to the end, let's do worst case scenario, the division believes ORN made a mistake. And even when they reviewed it and went through the appeal process, the division believes that ORN made a mistake, and it's the division's decision to say that ORN made a mistake. But you're not eligible unless you're certified. So what does that mean if the division says that ORN made a mistake?
Right. There just has to be a standard for the review. You know, there has to be a standard established for the review. There has to be some demonstration that we had violated some standard by declining to certify a nursery. You know, there has to be a standard around that. It's not open for interpretation.
Kelly, let's assume that we get all the standards done. We're still stuck with the state making the final decision and not really understanding. I mean, does that mean you just keep sending it back to ORN until ORN finds either a way to justify that this program really should not be certified, or says if they do X, they will be certified? I mean, is that what the final decision means? Is that you won't stop working with ORN until you're satisfied that the appeal has been treated equitably?
Well, I mean, you just take it to the other end. So the state decides that we've made a mistake and they're going to certify a nursery. Well, no, they're not, because we're not going to certify.
Kelly, nobody is saying that. Nobody is saying that the state is going to certify. We've all agreed certification is an ORN function. I'm just trying to get at, I think what we're saying is the state doesn't give up on the appeal process until the state believes that the organization has been treated fairly, and that may mean asking ORN to go through it over and over and over again. Is that what this means? Because nobody is saying that the state is going to do certification. We've already said at the beginning, number one, ORN does it. Number two, you're not eligible for state funding unless you did it. So this is the question of how do we treat fairly. So I have a question for David and Lisa. Is the consequence of the state deciding that ORN made a mistake that we just keep looping through the appeal process until there is agreement between ELD and ORN that we have treated a program fairly?
I'm not sure that's the right way to frame it, Bobby. I think when you reference the ORN certification in statute and rule and tie funding to it, then there has to be some kind of legal appeal to some kind of public entity. That public entity could be the early learning division. I should say, but it could be like some kind of administrative court as well. But in either case, there needs to be some kind of final appeal, but that appeal needs to be based on those standards. But yes, it would be binding. There has to be some final binding decision. It does not necessarily need to be the early learning division that does appeal process. It needs to be a public entity. So I would give me research, but I can imagine you could create some other kind of legal framework, which may even draw the ORN certification process more into the legal orbit. I think, to be honest, this is probably the simplest and cleanest way of having that minimum appeal. That's, I think, necessary.
Well, I can't imagine this ever happening, but we have to get the rule right anyway. So we're not in consensus, and the next step is staff is going to do some more exploration on the options for the final decision. How's that? Is that where we got?
How about we do it 5 by 5?
Oh, sure. Okay. Okay. So are we in agreement that we need more information on the appeal process, and we would like more information on who might possibly be, what public entity might be able to make the final decision? ELD or somebody else, but you'll come back to. Okay, is there anybody who would give that decision less than a 3?
Bobby, hang on one moment, please.
But that somebody else has to be a public entity.
Yeah.
So it could be.
Yes, a public entity, ELD, or a different public entity who would, the rule would say, would make the final decision if the appeal process did not result in resolution. Lisa, David, is that what we're saying?
Yes.
Okay, anybody give that less than a 3?
Me, Kelly.
What would you like us, what additional information would you like us to gather? We're not voting on this, we're not saying there's consensus. What we're doing is what's the next step. So what would you like to be the next step, Kelly?
Well, Bobby, honestly, I'm unclear what the next step would be. This is something that we've not found consensus on amongst the entire time we've been speaking to one another, and we're hearing that there are rules and regulations which apply, and law that applies from the perspective of the ELD, but we need legal representation ourselves, and we need to understand that.
Okay. So then, so ELD will go to find out if there's what public entities could be the final decision maker, and ORN is going to pursue the same question, or however you frame the question about what, how to resolve appeals in which the ORN says a program does not meet the standards, but the program has made a case that other people believe shows they did meet the standards. So,
Bobby?
Yes.
For the record, I would like to also explore if we should just move to standards instead of going this way, because this seems a lot more fraught with just lots of various places, whereas if we shifted to standards for the state, and also either we have people meet these standards or they get certification through ORN and they could get these funding. But I want to put that out there for our staff.
Okay, I'll take that. Okay, we can take that standards and that ELD could determine. Okay, so that's a view. So there's there's three next steps. Three things we'll take to council to say are under consideration. One is considering possible public entities to be the final decision maker. ORN is going to do whatever exploration they can to find out what options they think are available. And the third is that we'll say that it was raised that the ELC should consider simply not requiring ORN certification and say they may get it through ORN or they could get it directly from ELD. So we're certainly not in consensus, and those are the three things that I've heard to take to council and for people to do in the month before our next meeting.
This is Kelly, and I strongly disagree with the third option. I have absolutely no idea where that came from. That doesn't represent any of the good faith conversations that we have had or the work that's even represented here. I strongly disagree with that being part of any record that the ELD have some other entity or method of certifying a nursery.
Kelly, this is the Child Care and Education Committee is the rule advisory committee to the council, and a member of this committee has said that, and so it's got to be, it is in the record. It doesn't mean that that's what the council is going to do. It just means that a member of the rule advisory committee has stated an opinion, and that's all. That's what it means. And I mean, we can't make it not happen. It's what it is. So.
Bobby, this is Lisa. I'm sorry, I just want to do a time check. We have 10 minutes left in our allotted hour, or 2 hours.
Yeah, I've been watching too. It's clear. I do want to go to the next section, and let's try and get through that. It's eligibility. I think we know what we need to do, and everybody has some work to do. So let's go to eligibility for funding.
Huge. We can't rush through this. This is Kelly. I think this is a very big issue, and I just feel like we're going to be rushed through this in 10 minutes. I mean, I have to leave at 3 o'clock today on the dot, and I really don't think opening this up right now is useful.
You don't even want us to look at
it. I concur with Kelly. I think we don't. I think there's some bigger things I don't want to have a complicated conversation about, so I agree with you, Kelly.
Thank you, David.
Okay. David, I'm sorry that I didn't hear one word of that.
Well, I was just saying I concur with Kelly. I think there's some...
Okay, that we shouldn't even open it up. Well, then let's just talk about next steps. My concern is that we didn't even make it halfway through. I could be hard-nosed and shut discussion down, but it doesn't feel good. I guess we'll take this into consideration and we'll communicate with you by email. It would help if people have time to work their way through the rule and identify issues and maybe send those to me ahead of time so that maybe we can say, nobody raised an issue on this, can we go through it relatively quickly and leave plenty of time. The sections that we spent a lot of time on, it didn't feel like we should shut that discussion down. But we do need a way to move more quickly. So I will send out an email, but I'm asking everybody to read through the rule for anything that they consider to need more complete discussion, and so that we can prioritize the amount of time we spend on each section. So we can get through.
I would like to also just remind you we have, we should open up for other public comments if we have any.
Oh, thank you. You're right, Lisa, I could have forgotten. I am so sorry. We have 9 minutes, so we would love to hear from the public.
This is Mary Ellen. I'm trying not to beat a dead horse, but I'd like everybody to consider once again, and I'd invite any members of the committee who are not completely familiar, because I don't know all of you, completely familiar with the relief nurseries, to call me and we can talk about what they are and they aren't. It might clear up some or come for a tour, better yet. It might clear up some of the skepticism that you have about the relief nurseries and what they're doing, and OARN in the certification process.
So, Mariel, it's okay with you then, I'm assuming, if we send your email address to committee members?
Absolutely.
Okay. All right.
Hi, this is Cindy Vaughn.
Yes?
Hi. So having been a new relief nursery, working with ORN, between our certification specialist and certification committee and replication, there is so much support that a new entity gets become a relief nursery. You know, I'm not sure there's an understanding, and I think talking to Mary Ellen is huge, because the work that goes into helping an entity prepare for relief nurseryhood is amazing. And you know, our goal is to certify nurseries, not to have people or entities go through all this and to be turned down. So we would do everything that we can to work with them. So I just want to have that out there.
Thank you, Cindy. That's why, I mean, I know we have to put it in the rule, but I don't expect it to ever be used.
Bobby, Lisa,
No.
Bobby, can I offer to send out Tim Rusk's presentation that he presented to this committee? I'm going to think it was July or August when we first initially started this. I'll resend that out to the committee members.
Okay, along with the request to please identify any areas of the rule that you think we should pay special attention to. Okay?
Bobby, this is Charlene.
Okay.
I just wanted to say that I do think if there is any doubt about the process, the certification team would come together at whatever site anyone would like to have a tour of and really work with them to answer their questions and help them to understand the process, because it is a very thorough process. It's been very well thought through and it's been in place for many years. And I just want to echo what Cindy said. I mean, our goal here is never to omit someone from the process. We do everything we can to really support them to strengthen their ability to be funded. That's what we want, because ultimately then more children get served, and there are so many children in the state who need these services.
Thank you. Okay, so there's an open invitation, and this will all go out now, to talk with Mary Ellen and to request a on-site visit. Is that, Charlene, did I get it right? You provided an invitation?
Absolutely.
To on-site visit. Okay.
Absolutely.
So that'll go out.
That we could find a location close to wherever the people are that would like to see it. You bet.
Okay. So, all right. Then, any other comments? Okay, we all have work to do, and so you'll be getting an email, and I hope we'll be getting responses, and then we'll meet in a month.
Thank you.
Thank you, everybody.
Thank you, Bobby.
Thank you.